The IRS has the power to issue a summons to pursue unpaid federal taxes and people that owe them. The IRS may want your money. When the IRS issues this, it must generally provide notice. Of course, anyone entitled to notice may bring a motion to quash. So they say, we'd like money. You can say, no, go away. You can file a motion with court, say no. But when the IRS issues a summons in aid of collections with an assessment, no notice is required. So sometimes they have to give notice, sometimes not. So sometimes they issue a summons in aid of collections of assessment made against a person to whom liability is required, no notice. In this case, however, the IRS official did assessments with respect to Romo Pelosi for more than $2 million in taxes. The revenue officer issued the summons to 3 banks seeking financial records relating to third parties, including petitioner, who then moved to quash. So the IRS thinks, hey, this guy owes us money. We'd like to get access to the records, but they're not his records. They're in the possession of banks. Okay, let's issue them a summons. But we did not give them notice. We just issued them summons, okay? And so they say, well, you can't do that. You can't give us those summons. We're not going to do it. The district court concluded under the relevant law that no notice is required, and the petitioner therefore cannot bring a motion to quash. District court says, you can't fight this. Give them the records. The Sixth Circuit affirmed, finding the summons fall within the exception to general notice. So if they're the petitioner's records, no notice. You have to give it to us. You can't fight us. Give us the records. Third parties, is it the same rule? Can they get the records from the bank? The Supreme Court rejects the argument that the exception to notice only applies if the delinquent taxpayer has a legal interest in the accounts or records summoned by the IRS. So one of the issues is, hey, are these accounts owned by the guy that we want to get the records from? So maybe the exception is relevant if they own the account. That's the same thing as it being their record. Maybe that's the rule. But we're going to say, no, that's not quite the rule. The statute sets forth 3 conditions to exempt the IRS from providing notice. First, a summons must be issued in aid of collection. We'd like money. Second, it must aid in the collection of the assessment. It will help us get the money. Third, the summons must aid in the collection against the person. You're the one who owes us the money. We need money. This will help us get money. You're the one we want the money from. The statute does not mention a legal interest requirement, much less that the taxpayer themselves maintain such an interest for this to apply. So we've been, going after taxpayers using this authority for a long time, but the statute also seems to allow us to get it under third parties. And they say, wait a second, he's not the guy. He doesn't own the accounts. And the court says it doesn't matter. The exemption only has to aid in collection. So no notice for you. The arguments in support of the purported legal interest requirement do not convince the court to abandon a reading of the statute. So the argument was, hey, if this guy has an interest in the accounts, then maybe that's fine. But if he has no particular interest in the accounts, they're not his accounts, they're not owned by him, then obviously maybe that's a different rule. Now, just the fact that he doesn't own the accounts doesn't mean that they're not his accounts, of course, right? They might be ostensibly in the name of someone else. So the fact that he's not the legal owner, or not even legally the person who is, messing around with accounts, doesn't mean that he isn't messing around with the accounts, right? Because people try to hide their money in all kinds of interesting, creative ways. But he's not listed as the ordinary. He's not listed as the account holder. But the IRS says, well, we want the records anyway. And the court says, yeah, give them the records. Petitioners contend the phrase "in the aid of collection" refers only to inquiries that directly advance collection efforts, which a summons will not accomplish unless it's targeted in an account containing assets the IRS can collect to satisfy the taxpayer. This, of course, ignores the ordinary meaning of "in aid of." To aid of means assist. A summons that may not reveal taxpayer assets can nonetheless be helpful to finding the assets. So yes, it may turn out these are not the right assets. But if the IRS has enough information to make the request, then maybe the answer will help to reveal other accounts, because maybe those accounts that we summoned are transferring other accounts, or they're in a chain, right, of chain. So maybe this itself won't reveal the answer, but it might be a pebble along the way, because maybe it's an account connected to account connected to account connected to a guy, and we can find the rabbit trail by tracing the money. We'd like to trace the money. Petitioners next argue that to read it to exempt from notice every summons that helps the IRS to collect an assessment, there'd be no left work to do by the notice requirement statute. So, hey, if you did this, then the notice requirement thing would be moot. The clause exempts notice from any summons issued in age of collection of liability, of equity, of any transfer or fiduciary of any person related to the clause. So basically your friends, your banker, your lawyer, anyone you might be associated with, because, we know how people like to manipulate the money, and we're not that dumb. The two clauses apply in different circumstances. One clause applies to an assessment. A different clause applies to liability. So one clause is how do we calculate the money? The other issue is who owes us the money. In addition, the clause concerns delinquent taxpayers, while a different clause concerns transfers or fiduciaries. As a result, the clause permits the IRS to issue unnoticed summons to aid in collection from transfers or fiduciary before it makes an official assessment of liability. So if they want to come after you personally, for the money, they'd like you to pay the money, they have to give you notice. So if they want you to give them the money, if they want to come after you civilly or criminally, yes, they have to give you notice in that circumstance. But if all they want is the records, they don't have to come after you for that. Give us the records, they say. The rest may or may not follow. Yeah. The court does not dismiss any apprehension about the scope of the power and does not define the precise contours in aid of collection. So, we're not going to completely define the term, but this is fine. The briefing by the parties and the question presented focus only on this relative issue. The answer is no. Roberts delivers an opinion for a unanimous Supreme Court. So the IRS ability to get records, well, great. Thus, that brings us to the end of this case dealing with the IRS and their ability to get information as it relates to financial liabilities. The IRS thinks this guy owes $2 million. In order to figure that out in further detail, they would like to get access to banking records. And they give the banks basically a subpoena. Well, they call it a summons, but basically the same idea, right? Give us the records, they say. The bank says, wait a second, no. These accounts don't belong to the guy. These aren't these guy's accounts. What are you talking about? You can't get it. And the Supreme Court says, yes, you can, because it will aid in collection. The IRS apparently believes they have enough information that these accounts have some sort of relation to the guy, and that apparently is enough because it will aid us in collection. Now, maybe we'll get the records, and maybe it will show us this is the guy's money after all. Or maybe it won't show us this is the guy's money, but maybe it will show us some transfers and some other people who are related, perhaps in a conspiracy, right? This is an account that is transferring money along the way from hop to hop to hop to try to hide the money. Other people involved in a potential conspiracy. Maybe it will aid us in figuring out who those people are and what those accounts are. Give us the records, and we'll get other records from other banks and other people and other records from other banks and other people. And if we decide that those people owe us money, we will absolutely give you notice in that circumstance. But otherwise, not so much. Just give us the records. And so the IRS gets to get the records and follow the money trail. Very exciting for the IRS. And that brings us to the end of discussion of this story. Yeah, your toddler, right? Yeah, like Mike Ehrmantraut. We can't help noticing that this bank account is in the name of Kylie Ehrmantraut, 6-year-old and just cute as a button. Now, my partner over here said, shit, man, this 6-year-old is the mastermind behind Fring's all operation. But I was like, whoa, Goma, slow down. Maybe it was actually her dear old grandfather. Great insight there, right? Yeah. So, exactly. Yeah. So,